Welcome to the African Climate Alliance podcast, where we aim to answer the questions, what does climate justice look like in Africa, and what will it take to achieve it? In this second season of the podcast, we are talking all things cancel coal. Over the course of the 5 episodes, we will dive into the multifaceted impacts of coal mining and the way forward for our energy future. From frontline advocates in coal-affected communities and legal experts discussing the environmental crisis to the transformative power of spiritual leaders, each episode delves into the diverse experiences and perspectives, encouraging us to engage with the urgent need to cancel coal for a just and sustainable future. The conversations on this season are hosted by Sarah Farista and Otila Nkarimen, 2 intersectional environmental activists and members of our Cancel Coal Youth Task Force, who both embody what it means to speak truth to power and call for justice and change. The task force is a small group of dynamic young activists across South Africa who are campaigning to stop the new coal-fired power. In today's episode, we are in discussion with Brandon Abdinor from the Center for Environmental Rights. We will delve into the legal aspects of #CancelCoal, exploring its constitutional basis and implications for the future. Let's dive right in.
Welcome to the African Climate Alliance podcast. I'm Mutsile, and today we are delighted to be in conversation with Brandon Abdinor. As we chat all about the power and money dynamics within South Africa's energy landscape and what lessons we can learn for an equitable and just transition. For those of you who aren't familiar with Brandon joined the Center for Environmental Rights as a climate advocacy lawyer in 2021. In this role, he engages with climate change-related laws and policies with a view of helping to ensure that these are effective and advance the needs of climate justice for all. The role includes liaising with a wide range of stakeholders to gather and share information and build consensus around legal advocacy in pursuit of an increasingly sound and just climate response. Brandon, welcome to the African Climate Alliance podcast.
Hi, Otsile, and thank you very much. Thank you for this opportunity to talk about this important work. It's always good to get this information out there, debate the ideas, and really gain mutually increased understanding. And it's always a delight to engage with the African Climate Alliance. So I'm very happy to be here.
Hear, hear. Brandon, can you explain to our listeners the significance of Section 24 of the Constitution and how it relates to the Cancel Coal court case?
Absolutely, yeah. So we've got a very progressive constitution with a Bill of Rights that addresses a range of different rights, and very happily for us, including the right to a healthy environment in terms of Section 24. The right is split into 2 parts, an A part and a B part. And the A part's quite simple. It just talks about the right to an environment that is not harmful to health or well-being. And this is an unqualified right. So it's simply put there. There are no sort of qualifiers that modify it in any way. And this is obviously relied on heavily in the case. But as is part B, which is a qualified right, and I'll explain that in a moment. But this talks about, firstly, and this is key for our case, is that right being in place for present and future generations. So that really lets us know that whoever drafted this right and the Bill of Rights really understood that a healthy and a non-harmful environment is not only necessary for where we are and what we're doing today, but also tomorrow. Why it's qualified is that it then goes on to say that the state must take reasonable legislative and other measures to prevent pollution and ecological degradation, to promote conservation, and to ensure ecologically sustainable development. So that word reasonable there is where a qualification comes in, because it can be a matter of opinion what is reasonable. We know that this case is being opposed by the Minister of Mineral Resources and Energy. And the arguments that come from the other side, therefore, is that they are being reasonable and that the steps that they are taking are not an unreasonable limitation of this right. There's then a final part that talks about, so it needs to be protecting the environment, conserving, etc., while promoting justifiable economic and social development and the use of natural resources. The second part of the Section 24 right for the environment is a qualified right, and I'll go into what that means. And that talks about ensuring that the environment is protected for present and future generations. And this is obviously a key point in terms of this particular cancel coal case, because it is youth-led, and this notion of future generations needing to have the environment protected for their benefits is a very powerful leg on which the case stands. So this part B of Section 24 talks about the state taking reasonable legislative and other means to prevent pollution and ecological degradation, promote conservation, and secure ecologically sustainable development. So that word reasonable there then qualifies the right, because that means that there could be certain cases where environmental harms occur or the environment is not adequately protected, but it is deemed to be for a reasonable basis. So, I mean, you can just imagine we can't have no development at all. We can't be in a situation where we can't take actions such as building human settlements or whatever it might be that has absolutely zero harm. So really this is saying that certain harms, when weighed up against the benefits of those actions, can be thought of as being reasonable. And this is where a lot of the case will turn, because those who are pushing for the new coal-fired power will say that the action is reasonable, that we need that electricity, that this is the appropriate source for it, and that therefore it should be allowed. And there'll be key arguments around that. There's another aspect to this, because it talks about sustainable development, ecologically sustainable development, the use of natural resources, and promoting justifiable economic and social development. So here too, they're basically saying that the environment can be quote unquote harmed in cases where it's done so in a sustainable way and where it's justified and where the use of the natural resources is appropriate. So again, a lot of the arguments will come around this, and in many legal actions and other advocacy exercises, this is often the two sides of the coin, where those who want the environment protected will say this action shouldn't happen, and those who want to take the action will say that it's justifiable. So this is something that will be developed throughout the court papers, and when we finally in front of a judge, these are some of the key arguments that will be ventilated. And then finally, just to point out, it's very important to note that even this right to a healthy environment is people-centric. So it says that people have the right. It doesn't say that the environment in itself has the right. So there are moves across the world to actually give certain rights to components of the environment, such as rivers or certain ecosystems, and that's a whole separate thing. But many detractors, when we are defending environmental rights, say, oh, we're choosing the environment over people. But if we look at how this right is worded, it is in fact to protect the people, because people need a healthy environment.
Thank you so much for that, Brandon. And what struck me was when you said that very often environmental rights are seemingly pushed aside for economic benefit. But I think that the way in which we think about the environment, and the way in which we think about a society and how it's structured, we should view it as the most valuable resource we have right now is nature and the environment, because from that, everything else is structured and built. You can have the best economy in the world, but if your people are struggling with poor air quality or aren't able to access clean, safe drinking water, I mean, your society is inherently flawed. And so I'm very glad that you were able to touch on that. And I think that really drives into the second point that I have here, which I'm pretty sure you've already touched on, but maybe you can go a little bit deeper into it. Is what are the key legal arguments being presented in the case against the government's plan for the new coal-fired power stations?
Okay, yeah, great. There are a number of pieces. So just to build it up systematically, the first really is the basis that climate change is real. It's real, and the need to respond to it and to slow it down and halt it and reverse it is urgent. The second one is that if you think of the nature of climate change, we're really starting to see the impacts now. If we look carefully, we'll see that the impacts have been happening for decades already. But they're starting to arrive thick and fast, and all the science agrees and understands that this is only going to intensify. So even with the best climate action in the world, we're going to be dealing with impacts for a long period of time. Hopefully, if cases like this and others are successful, we will be able to reduce that intensity and eventually return back to a completely healthy climate and environment. But because of the nature of that, it is the future generations, so it's children, people who are currently children and those even to be born, that are really going to be sitting with these impacts. So that's an important leg of the case from the youth-led angle, is that the rights of the child need to be looked at over here. Then a third important leg is that it's absolutely agreed and understood that coal-fired power is the most significant contributor to climate change. Coal started being burnt in the mid-1850s. The harms were not known at that time, although certain visionaries at the time, towards the end of that century, actually recognized it, and we've seen warnings that as early as 1912. But understandably, that knowledge became more mainstream over time, and it's really in the late 80s where it became incontrovertible, and key decision makers from that point in time couldn't claim that they don't know about it. And then there are also the health impacts of coal. Toxic emissions that degrade the air quality, such as sulfur dioxide, nitrous oxide, particulate matter, cause respiratory and other illnesses, heart disease, asthma, preterm deaths. And these are also put into the court papers as being parts of the harm. So really that collection of arguments that I've mentioned there lay the foundation to say that coal and new coal-fired power is really not appropriate. It then goes on to look at our constitutional rights, because these rights should not be limited, and they certainly should not be unjustifiably limited. And we're saying that this action of pursuing new coal-fired power does unjustifiably limit a number of constitutional rights. And we've already spoken about the right to a healthy environment in terms of Section 24, but there's more. There's the right to equality. We know that it is certain people and certain communities that are more at risk than others. And these often follow general socio-economic lines. So if we look at the communities that live around coal-fired power stations, these are often more economically marginalized communities, and they're left to bear the brunt of these impacts. Given the nature of climate change, we're saying that the right to dignity, life, food and water are also compromised. So we need to see those rights being upheld. And then finally, there's a right to have the interests of the child made paramount, which is a very noble right to have. And it makes absolute sense. And again, because of this nature of the climate crisis and the long tail of the impacts, we're saying that that right is also compromised. So those constitutional rights are one aspect of the case. So we're saying this action unjustifiably limits it. And then we also invoke the promotion of administrative justice right. And what administrative justice really says is that any actions or failure to take action by state decision makers needs to be rational and it needs to be reasonable. And then we make the case that new coal-fired power, because of its climate harms, because of its health harms, because of the fact that it's actually an expensive choice compared to alternatives, is therefore not rational and it's not reasonable to take this action and make this decision. So we're saying that in addition to limiting the constitutional rights, this is not administratively just action, and this becomes another leg of the case. And then finally, we look at the principle of legality, and we're saying this decision the decision makers did not take into account adequately the views of those who expressed concern. The IRP, or Integrated Resource Plan, which is being challenged here, was subject to a public participation process, and many stakeholders brought to the attention of the Department of Minerals and Energy the potential harms of this decision. And we're saying that these were not considered adequately. And then finally, that the decision to build new coal is not rationally connected to its purpose. So the purpose is obviously to create electricity. But because there are alternatives that are cheaper and less harmful, we are therefore saying that the decision to choose coal is not connected to its purpose, and therefore we're questioning the legality of that decision as well.
That's particularly interesting, that you say that. One thing that stuck out as you were explaining is that, that there's certain things that are put at increased jeopardy, and that are things such as food and water. And I was thinking back to, what universally we as human beings should all expect other human beings to have as we live about our lives on this earth, and that is we should have food, water, shelter, safety, and security. If a person has those things, there's little else in this world that they actually need, I think it speaks to the nature of why this case is necessary. The fact that these things are put at risk for disenfranchised, marginalized communities that are the most at risk when we're talking about the impacts of climate change. Why a case like this is so well timed and is needed, especially in a country like South Africa, where we talk about record levels of inequality. I mean, it just struck me as you were saying that. But you touched on, how cases like this can also help set international precedents, where if it was done in South Africa, it can give inspiration to other teams around the world that want to do this type of work. And that flows very well into my next question, and that is, how does this case in and of itself align with international climate justice efforts, and what impact could it have globally?
Yeah, that's a great question. So the first angle will really be, because we go very in depth into climate mitigation. Every case that is brought anywhere around the world that develops these arguments just moves the needle that little bit further. You then start to get a situation where courts and judges hear these arguments. Every time they hear them, they get to understand them a bit better. And then, because the campaigning is such an important accompaniment to the case, that then happens for journalists, for members of the public, for people who are possibly skeptical. These arguments are unpacked very, very carefully and very solidly on the best available science. So the science of climate change gets ventilated, gets explained, gets proved. And this creates like a deeper understanding. And really, one of the important things that is needed for universal climate justice is that a critical mass of people out there, in whatever walks of life, get to understand the issues and get to ultimately vote in some form or another, or express support for actions that will protect and preserve the climate and the environment versus those that harm it. So, which is one of the very important things of climate litigation. In terms of raising awareness, journalists and media houses love court cases from the point of view is, if someone's gone to the trouble and the expense of actually putting a statement or an argument or evidence in court papers, it means that it's got a higher degree of credibility. That's not to say that, in all court cases, everything that's said by everyone is necessarily credible, but certainly it gathers a lot of attention. And then obviously there's this amplification effect as people read about these things and understand them. Another aspect of sort of international climate justice is, we talk a lot here about the consultation that took place before this decision was made. And an important leg of this is consultation with the youth. So I think if we look back over recent history, we can probably say that, first of all, consultation has not been taken very seriously. It's often been well, it probably never used to happen at all decades ago. And then when it started becoming a requirement, it used to get done, but in a very tick box exercise. So it's almost that you get this feeling that the decision makers decide what they want, and then they have to go through this, for them, annoying requirement of consultation. And these are often done very poorly. Perhaps very technical information is given to people at a venue that might not be accessible in languages that they may not understand. So by highlighting the need for proper consultation and consultation with the youth in particular, given the nature of the climate crisis, that again pushes the needle in terms of participatory democracy. We really want to get all the voices onto these tables where these decisions are made. And then finally, it highlights the harms. So, I mean, this is not a comfortable topic, but to say to the court that, look, this action is causing harm, we need to go into that harm. So we actually then use, again, scientific information to, first of all, look at what's happening globally, how greenhouse gas emissions are causing warming, and the warming is causing climate change, and the climate change in turn causes other physical impacts such as floods, droughts, wildfires, heat waves, and extreme heat events. And by unpacking them and drawing the linkages, again, it provides information. So people may be considering a case like this in a country around the world, or they may be researching it and wanting to write a paper on it, or maybe wanting to understand the issues so that they can talk to their communities and their neighbors. And by having all of this information and the evidence of how one, on which one bases one's allegations, grows the pool of public knowledge around these things. And again, it educates the courts and the judges and hopefully the politicians as well.
And I suppose the precedent that it sets helps us going forward. Because more as this body of thought keeps being developed, and becomes a source of law, that other legal scholars can go back and look to, it would be very useful.
Yeah. Yes, yeah, it's very useful. Like the first time these arguments are put before a court, they're novel, and you're almost having to prove them from scratch. But as they get put before courts more and more, that it starts to become a given or an accepted. And these do create very important precedents, both in a very strict legal sense, and again, just to add to that pool of knowledge that anyone can draw on for whatever advocacy, campaigning, legal purposes they want.
100%. And so I suppose that takes us to the next question, and that is that, are you able to walk us through the process of preparing and presenting a case of this nature, especially when led by youth plaintiffs?
Yes, absolutely. So, I mean, you can well imagine that a case like this requires tremendous preparation. And it requires a lot of conceptualizing well in advance of even starting to contemplate actual court action. So in this particular case, I guess a very strong ground from which we drew and on which we based the case was our work, which we've been busy with since about 2013 on air quality and air pollution. And a lot of this is, given the nature of South Africa's profile, is because of coal-fired power generation. So because we were understanding and increasingly working with air pollution, again, from the scientific point of view, from the legal point of view, and then also from the point of view of the clients and communities we work with, we already had a strong sort of institutional understanding of the issues. And that naturally flowed into understanding the climate change issues. So the air quality is really, the emissions come from the same sources. On the one hand, you've got the toxic emissions, which cause the health issues. And then you've got the greenhouse gas emissions, which in and of themselves aren't toxic. But obviously, these greenhouse gas emissions create an unbalanced load in the atmosphere, and that's what's causing the warming. So understanding the science around that, understanding the sources, all of that required us to get a good understanding of South Africa's energy system. You'll find that climate change fights in most parts of the world will be around energy. They might look a bit different. In South Africa, it's coal. In Europe and the US, it might be more gas, for example, but really it comes down to the same principles. So understanding how climate change works, what the causes are, and what the underlying dynamics are that keep us locked into these systems was very, very useful and very important. And that gave us a head start in terms of trying to conceptualize a case like this one. And then a second important leg is the clients and the relationship with clients. And the one wonderful thing about the climate justice community is that we talk a lot, we collaborate a lot, we share a lot of information, and we often become good friends and allies and associates with each other. So the very nature of that is that people want to know what we know, and we want to share it. And the same goes for other stakeholders and role players. So through that, one starts to get an understanding of the community at large and then the specific community. So a lot of the air quality work is a lot more localized, whereas the climate change work is a lot more general because the harms happen everywhere. But by building these relationships and understanding the needs and the desires and the challenges of people, organically moves on to a position where someone could become a client for a case like this. So this very painstaking process of building those relationships carefully and building them and creating a space of trust is very, very important. One of the dangers of, I guess, formal civil society is that it has its objectives and it can sometimes helicopter into communities to meet its objectives and, in a sense, use those communities. So we certainly don't ever want it to be a case like that. It's more a case of, we know you, you know us, we know that you are experiencing these harms, you know that we have this legal knowledge that can help avert those harms, and therefore one gets to a point where one can, based on these very trusted relationships, go into this battle together, because everyone brings their part. And then with the youth side in particular, it's always important to protect clients. You know, it's, in a sense, a court case like this is a bit like going to war. You're going up against interests that want the direct opposite thing to you. So, you know, it can get hostile. And certainly people in fights like this are going to try and attack each other's credibility and motives and that sort of thing. So it's very important to consider physical safety. And fortunately, this particular case is not that risky in terms of physical safety because we're attacking a very high-level government decision. There are no actual businesses currently or portions of communities that stand to have their income taken away. Sometimes you have cases where you're fighting the expansion of a mine, and some of the people in the community actually work on that mine. So by fighting the expansion, you're threatening their jobs. And that's where things can get physically risky. That's not so much the case here, but nonetheless, you're still going up even if it's in a less direct way, against powerful interests. So one needs to have protocols in place. And then particularly with youth clients as well, these fights are hard and they take years. So it's very important to be mindful of the mental and emotional well-being of clients as well. When a case like this breaks, there's a lot of media interest, and yeah, there are many wonderful and ethical journalists out there, but some not so much, or perhaps they're just a bit thoughtless or careless, and they may just want comments from people and sort of ask around for numbers, contact people without necessarily explaining what they're wanting, and the people are not maybe understanding why they're being asked certain things. So really just to create a space where people's identities are protected as much as possible, that they're not harassed by journalists or others, and that they're not sort of able to be identified by people who might wish them harm in some sort of way.
Yes. And so, you know, I thought, as you said, that, you know, very much preparing for a case like this is like going to war. Very, very often in situations of war, in the fog, each side believes they're on the correct side. and that they're fighting for the inherent good. But given everything you've outlined so far, I think to anyone listening to this, the work that you're doing is for the inherent good in this situation. And I suppose that leads to the question, in war, you're fighting for a specific cause. In this case, where, you're fighting for what is a very right cause, to defending what is a very correct right for people. It links very well to my next question, and that is, what are the outcomes, the potential outcomes for this court case, and how might they shape the future of energy policies in South Africa and beyond? Because that's ultimately, where we're aiming with this.
Absolutely. I mean, we're really coming from the premise that, yes, we need electricity. We need affordable electricity, and we need clean electricity. We need electricity for development, education, healthcare, and all of that. So that's not the issue. What we're saying is where we get that electricity from is important. And where we're sitting now in 2024 and have been for some time is that we know that new coal-fired power is simply not necessary. We know that we can get electricity from renewable energy. It's important to distinguish here. We're not saying that the existing coal in this case must stop overnight. We also know it needs to stop as quickly as possible. But in this case, we're just saying don't continue to lock us in to this dirty, expensive, unreliable system that is going to cause untold harm if left to its own devices. So a good outcome in this case, if the claims that we are putting before the court are accepted and upheld, it effectively has the potential to really put an end to new coal-fired power in this country. Because although we're not asking the court to declare coal-fired power illegal, that would be a whole different matter. But we're just saying that this particular decision, but if the court agrees with us that this particular decision is inappropriate because of the harms, it really effectively then puts an end to new coal-fired power, because any future attempts to do the same would now very simply be able to be challenged. So the idea is to swing the course of our electricity generation trajectory from this dirty and historical way of doing things to a cleaner and newer way of doing things that has a lot of benefits as well as far fewer harms.
I 100% agree with you. There's a reason they're called fossil fuels. They're of a bygone era. I like to think of them as having that double meaning. Not only are they made of fossils, but they literally are of that fossilized era. It's time to move on to bigger, better, more new, innovative means of generating energy. But, ultimately, the concerns that many people have with talk like this is that how do these types of talks address potential economic impacts, from transitioning away from coal, particularly with the focus on communities that have been historically dependent on the coal industry? So I was hoping you could maybe shed some light on this for us.
Absolutely. I think I'll start more generally and then I'll zoom in. From a general perspective, I mean, this is your question is an absolutely perfect illustration of the challenge of a just transition. So how do we move from a carbon-heavy economy to a decarbonized and climate-resilient economy and society? And it's not an easy task. So the idea is that we don't leave anybody behind. And the just transition, in fact, the concept arose out of the labor movement in the USA, also in connection with those who would stand to lose their jobs if certain environmental protections were brought in. And the principle there says, why should those people who may just be unlucky enough to be in that industry pay the price for the greater benefit? So it covers all interventions which would minimize that harm to those people and distribute the costs of decarbonizing fairly across people in society, and also distribute the benefits fairly. So that's in general terms. And if one can think of sort of the obvious example would be to say, take someone that's working in the coal value chain and reskill them to be able to work in the renewable energy value chain. It's obviously more complex than that, and it's not necessarily always going to be a case of direct swap from one way of doing things to another. But if we take the whole basket or the whole collection of interventions needed, we can start to think creatively of how we address the impact on employment. For example, it's not that we only need to stop burning coal for electricity. We need to rehabilitate the many unrehabilitated mines from which that coal came. We need to restore ecosystems for all sorts of reasons, to protect our water sources, to promote biodiversity. But also a healthy ecosystem stores carbon. So it's directly a measure which counters climate change. So if we think of it more broadly like that, we need everyone to get on board to be able to see how we make that switch in a way that's fair to everybody. Zooming in a little bit, what's really amazing about this case and some of the evidence that's been put forward, for example, we have a report from the Energy Systems Research Group at UCT, and they modeled what the impacts are of going down this new coal route versus going down a least cost route, which would be renewable energy. And they found that the net impact on employment far favors the renewable energy route, that there'd be a lot more job losses if we stick with coal, and that many more jobs could be created in a decarbonized situation. The court papers talk about a report from the CSIR, which said that if there was a 95% decarbonization, so in other words, we cut our greenhouse gas emissions by 95%, there could be between 112,000 and 140,000 jobs created by 2030 and over 300,000 jobs by 2050. And these findings are based on modeling by experts. So the court is going to be able to see that the claims that are going to be made by the other side that sticking with coal is good for jobs in the economy is absolutely not true. If a high carbon economy was good for socioeconomic well-being, why do we have such a messy socioeconomic system with the highest inequality rates in the world? So it's simply not true that sticking with fossil fuels is in everyone's benefit. In fact, quite the opposite.
100%. I agree with you when you say that. I was thinking as you were speaking, one of the countries that people make an example out of in the case for sticking with fossil fuels is India. They say, look at how fast India is growing. I think people fail to understand that, yes, the economy is growing in India, but you see the divide between people doing well and people living in extreme poverty increasing. If you've looked at the figures coming out of there, I encourage a few of the listeners to do that. You'd see there a case example of how the growth, yes, exists, but it exists for the people who are already better off. Those who weren't better off are still trapped in that cycle. But I think that with that point, I can ask you perhaps to share a message that you'd like listeners to take away from this conversation and the Cancel Coal campaign as a whole.
Yes, absolutely. I think one of the key messages I would like to share is stand up for your rights. I know it's easy to say that and it's difficult to do, but that's what's happening in this case, is that people's rights are being stood up for. We have an amazing Bill of Rights. In many senses, one couldn't ask for more. But just having that right doesn't mean it's going to be upheld. So whether it's in a big way, like a court case like this, or whether it's at a public participation meeting where you actually want to be addressed in your home tongue so that you can understand what's being talked about, put your hand up and stand up for the rights. That's going to be a way of pushing back at the system, which would happily steamroll us if we didn't do that. A second message is keep on understanding what the causes of the harms are. And in this case, we're talking about burning coal. In the very vibrant energy debate in South Africa, we see that actually that simple truth getting lost and distorted quite often. But the bottom line is, and the evidence is all there in the court papers, coal is harmful. We don't need it. So understanding that is very important. And then finally, I think this case highlights the interrelatedness of things, the interrelatedness of people, of communities, of issues, of environment, of people, economy, all of it. And really, whatever piece you work on, from whatever angle is important, and it all feeds into the same thing. If you're doing this work out of a vision for a more beautiful world, we're all pulling in the same direction, or those of us who've woken up to the importance of it anyway. We take our actions, big or small, and all of it moves towards making things better for everyone.
Yes. And I think that is the perfect note on which we can conclude our conversation. Thank you so much, Brandon, for participating in the African Climate Alliance podcast and for being one of the people helping to get the cancel coal court case through and defending our environmental rights. On behalf of a grateful generation of young people, I want to say thank you.
Thank you, Otsile. Thanks for the opportunity. It's been wonderful to talk to you, and more strength to all of us.
Yes, indeed. And thank you to our listeners. This has been the African Climate Alliance Cancel Coal podcast.
And that wraps up this episode of the African Climate Alliance podcast. If you found this episode meaningful, please share it far and wide. You can stay connected with us by following us on our social media platforms, Instagram, Facebook, and Twitter. This season supports the Cancel Coal court case. The court case is the first time in South African history that youth have led on a climate change court case against the government, challenging their plans to introduce 1,500 megawatts of new coal-fired power electricity. For more information on the hashtag Cancel Coal campaign and the court case and how you can get involved, visit www.africanclimatealliance.org/cancel-call. All links will be left in the episode description. Catch you on the next episode.